Good afternoon, folks. Sephton Leibbrandt. I'm an associate at Samfiru Tumarkin LLP, and of course, we are the employment lawyers. Good afternoon, or good morning, perhaps, if you're joining us from Alberta or BC. And thanks everybody again for tuning in for another great installment of our 30-minute Q&A sessions that we regularly host here. So hopefully we get lots of great questions as we always do in another productive session today. While we kind of wait for the questions to trickle in here, again, I am Sephton Leibbrandt, an associate at Samfiru Tumarkin LLP, and we are the employment lawyers, answering, of course, all your questions as we always do this afternoon or this morning, perhaps, if you're joining us from elsewhere. And it's going to be another great session today, I am sure of it. And I already see questions trickling into the chat, which is fantastic. But of course, on these segments, we answer all of your questions, anything perhaps to do with employment law, whether it's human rights, severance packages, terminations, everything and anything is that what to do with employment law, at least, is what we deal with here on our 30-minute Q&A sessions. So looking forward to answering some fantastic questions again today and really delving into a number of important topics in employment law. Generally speaking, folks looking for guidance in terms of what their circumstances are with their employers, because unfortunately, lots of times with employers, there's issues here and there. Nothing is always smooth sailing, especially if one is terminated and they're looking at the adequacy of their severance package and how much they're owed in terms of reasonable notice. That's paramount to most people's minds. How much money am I going to get because my employer has terminated me, without cause, potentially with cause, but often, it's without cause terminations. And, again, the money that the employer typically offers in my, usual experience is not what their best offer usually is. The first offer is generally not the best offer. And usually the most packages that I see are substantially below what employees' common law entitlements actually are. And of course, those entitlements are typically based on an employee's age, years of service, position, potentially rate of pay, and so on and so forth. But the key ones are age, years of service, and rate of pay, or sorry, age and position rather, years of service, age, and position. So one who is management, for instance, management level employees, of course, typically receive more money as severance package than folks who are non-management. Folks who are older, especially folks who are in their 60s, and upwards, generally receive more money in the severance package. But even one who's in their 50s, again, those folks receive more money than otherwise would be the case. And then of course, your years of service are absolutely paramount in the determination. Folks who have obviously more years of service, the usual assumption is that those people get longer severance packages. There is even, of course, potentially a circumstance where folks who have very few years of service or even months of service actually get disproportionately larger severance packages because of what the court has said about kind of negative stigmas that are associated with short service employment, and how it doesn't really look great, obviously, on a resume if you've been employed somewhere for 3, 4, 5, 6 months, something like that. You're terminated. It looks like even though maybe it has typically has nothing to do with you yourself as the employee, but it looks on your resume like, hey, perhaps this person didn't do a great job because of something that they did in the circumstances, which is often often not the case. And so what the law says is that those folks, those short service people, often get substantially greater severance packages, actually months instead of months kind of per year or so. We're looking at months, month per month, or something along those lines for folks who potentially are short service, depending on the factors there and so on and so forth. So a lot of great questions I'm sure will be trickling in here. I already see some questions coming into the chat, which is fantastic. But to jump back just for a second, obviously the key is, for most people in terms of a severance package, looking at, how much am I owed by my employer upon termination. And under common law, that amount of money can be up to 2 years of pay potentially if, the factors are correct. And so, a very significant amount of money there. Many employers only pay, the minimums under what's called the Employment Standards Act. If you're in Ontario, for instance, there's also Employment Standards Codes / Acts, in Alberta and BC as well. And those, have the minimum entitlements in them. And often, employers try to suggest that they only really need to provide the minimum entitlements, but that's typically, not the case in my experience. The vast majority of matters that I deal with, my client's entitled to common law reasonable notice. It's a substantially greater amount of money than the ESA minimums, the minimums under the legislation. And as a result of that, that's what you're pursuing is, again, a much greater severance package. And unfortunately, businesses, in my experience, are typically not generous. And so their first offer upon termination is usually, significantly below where your actual legal entitlements are sitting under the common law. So I'm seeing some questions trickle in here this afternoon, which is fantastic. So I'll jump to those now. If you're just joining us again, I am Sephton Leibbrandt, an associate at Samfiru Tumarkin LLP, and we are the employment lawyers. So it looks like, jumping into the questions, I got a question from Facebook. It looks like Leo has asked, my employer says I have to sign a new employment agreement that includes a non-compete clause or I'll lose my job. Can they force me to sign a new contract after I've already been working there for years? So Leo, to answer your question in that respect, the short answer is no, absolutely not. For one, non-compete agreements or clauses are illegal in Ontario, at least if you're employed in Ontario, for instance. Other provinces may be different. I'm primarily based in Ontario, but in Ontario, certainly they're illegal since about 2021, so they certainly can't be required to sign a non-compete in that respect. Otherwise than that, the requirement to either sign this agreement, otherwise than the fact that it's clearly illegal if you're in Ontario to do so. Otherwise than that fact, introducing this brand new term into your agreement with the employer may well be a constructive termination of your employment in and of itself. Typically there's no legal obligation for you whatsoever to sign off on a new contract. We get folks all the time. I get folks all the time who been offered a new contract by their employer. The employer may be offering a little bit more money for the contract, but the contract is actually substantially prejudicial. It's really disfavorable to the employee, in terms of their legal rights to sign off on the agreement. Perhaps some folks don't even have a contract that exists previously. Then the employer comes to them 10, 15 years into a relationship and says, hey, can you sign off on this new employment agreement here? We'll give you another few $1,000s for doing so every year. And a lot of folks just take that at face value and sign off, not realizing that in doing so you may be giving up tens, if not hundreds of thousands of dollars in severance entitlements upon the termination of your employment, because generally speaking, those new agreements have language or provisions in them that try to restrict you to only the minimum entitlements under the the legislation there, which again is never anywhere near what one is entitled to under the common law, which looks, of course, at your age, years of service, and position, primarily to determine, if potentially you're entitled to up to 2 years of severance from the employer there. So, Leo, again, to answer your question, it sounds like, again, this particular employer is behaving in an illegal manner, number one. If you're located in Ontario, it's no doubt about that. And then number two, again, there's no legal obligation for you to sign off on a new agreement. You can continue under the existing agreement. If your employer wants to terminate you because you will not sign off, that's their prerogative. They got to pay you at that point a severance package. And depending on what your contract says, with these folks, if there is a contract, probably you're entitled to common law reasonable notice in the circumstances, but definitely reach out to us and we can have a further look into that and the circumstances there. But a great question and a really useful one, because I see this all the time. Folks who've been employed for many, many years, and the employer wants to introduce a new contract. In those circumstances, absolutely reach out to us and have us, assess and review the severance package, or the contract rather, because again, the contract is typically extremely unfavorable to you, the employee, and really, potentially, may be requiring you to forfeit or give up, hundreds, if not, hundreds of thousands of dollars, potentially tens of thousands of dollars, certainly in legal entitlements upon your termination. So definitely reach out and get advice in that respect if that's something you're dealing with. Looks like a bunch of questions are coming into the chat now, which is fantastic. Looks like Brandon from YouTube has asked, I turned down unsafe work and my boss tried to convince me to do it by saying everybody else was, so I should too. When I stood my ground, he told me to do it or go home. How should I handle situations like this in the future? So Brandon, number one, I'm glad to hear that you refuse to do unsafe work under the course, I assume you're Ontario, for instance, under the Occupational Health and Safety Act. You have a right to unfuse unsafe work. And if your employer is threatening you with some kind of reprisal, telling you to go home or you're going to be terminated because you're not, doing the work that they want you to do, well, that's certainly may be a ground for a complaint under the Occupational Health and Safety Act, and to contact the ministry in that respect and have them investigate, the circumstances. Because again, I'm glad to hear that you didn't do the work that you felt was unsafe. If you feel any work is unsafe, ever in your employment, regardless if you think 100% that's unsafe or not, but you're concerned in that regard, again, you have a legal right not to do work that it may be unsafe in the circumstances, and the employer cannot reprise against you, threatening you with consequences for refusing that and exercising your legal right. That's very, very serious. So if this occurs in the future, again, stand your ground again, tell them you're not going to do the work, obviously, tell them that you have a right to refuse the work under the Occupational Health and Safety Act, assuming you're located in Ontario. And then again, if they, reprise against you, terminate you, tell you to go home, absolutely contact the ministry there. They could potentially look into this, investigate the matter, send investigators out to the employer and question them in terms of why they are requiring somebody to do unsafe work. If they terminate your employment, obviously, then you're maybe entitled to a substantially greater severance package, perhaps because they have reprised against you, which is illegal under the Occupational Health and Safety Act. And of course, you can certainly reach out to us in that particular circumstance there to get a further assessment of what your legal entitlements may be. But it sounds like you're on the right track. Again, make sure you stand your ground. Never, undertake work that you think may be unsafe. If you have any reasonable thought that this work may not be safe, even if you're not 100% confident in it, it makes more sense to decline it. And then again, if your employer wants to do otherwise, absolutely bring it to the ministry's attention. And if you're terminated because of it, absolutely seek the advice of an employment lawyer. And of course, we have folks standing by all the time, to assist and to review those kinds of circumstances. So you can of course reach out to us. The little link that kind of pops up below in the window there, employmentlawyer.ca. So I appreciate the question, Brandon. A great question, a really helpful one, because not one that I see too often come up, but because most employers are smart enough to know that if a work or if an employee is refusing unsafe work or refusing work because of that ground, that they shouldn't press ahead with it, and that they should respect the employee's rights in that regard. Again, given the serious legal implications of violating the Occupational Health and Safety Act there, this employer perhaps not that bright. So certainly reach out to us if things progress further. But I'm glad to see that you stood your ground there in that respect. Moving along here, looks like Rutherford from YouTube has asked, my daughter's been a seasonal worker for the last 4 years, typically spring and fall off in the winter. Spring, fall, off in winter. They said they aren't bringing her back. Is she owed severance? So the long and short of this question, or the answer to your question, Rutherford, is probably that your daughter is owed severance. Again, severance package to some degree depends on the contract that she signed with these folks. If there is no written contract, then the typical presumption is she is owed common law reasonable notice, which depends again on her age, years of service, as she's been there for 4 years, and the nature of her position at the employer, the availability of the work, and so on and so forth. But no, the long and short of it is, the courts have actually said that folks who are employed in seasonal capacities on kind of in a short-term nature, 4 years not the longest time, that those folks actually may be entitled to greater severance packages than people who are employed in regular kind of full-time employment, simply because during certain times of the year, it actually may be more difficult for your daughter to find alternate comparable work, which is the key, than it would be for other folks who are just looking for another full-time job. So certainly, have your daughter reach out to us, and we can have a look further in terms of what her severance package may be. But long and short of it, probably is the case that she's owed a severance package, and it may be a substantial one in the circumstances. Again, given that she's been there for 4 years, and if these folks aren't paying her anything, well, that's not the case that it should be. Certainly, after 4 years of service, continuously, even if one is employed on a seasonal basis. So definitely reach out to us there, employmentlawyer.ca, as well. If she wants just kind of a general hypothetical, not hypothetical, I suppose, but a general kind of assessment of what her severance entitlements may be. We also, of course, have a severance calculator that can be used, and she can kind of just anonymously plug in her information there. Pocket Employment Lawyer, you see the link is popped up below there, but plug in her information and see potentially how much she may be owed in a severance package from these folks in that respect. But definitely reach out to us. And we have folks standing by all the time to, again, get you to speak with somebody so that they can have a better, more thorough look at the severance situation here, the termination of the employment rather, and what the severance packages that may be owing to your daughter in the circumstances. So moving right along here, looks like we get another question from Melissa. Melissa has asked, my boss keeps texting me after work hours and expects me to respond right away. Sometimes it's late at night or on weekends. Do employees have the right to disconnect from work? So great question, Melissa, in that respect. The short and long answer to that is, yes. Folks, especially if you're on Ontario, for instance, there's legislation in Ontario that permits people not to have to answer, non-urgent communications, after regular business hours, 9 to 5. So if it's the case, that this boss of yours is texting you, after work hours, on weekends and things like that, you should not feel any obligation to respond to those, because again, you're not getting paid to do so, most likely. And again, the legislation says now that, basically in most circumstances, you do have a right to disconnect from work, not to be bothered by, work-related texts or messages or requests, after work hours. And, certainly it's something that you should raise with your employer and say, hey, this is what the legislation, says, could you kindly, please, stop, texting me, after business, regular business hours, or if you do so, don't be expecting a response, on a weekend, for instance, or after business hours. This is something that can, wait until the next day. So great question, Melissa, in that respect. Definitely something to bring up with your former employer. Not supposed to be happening in circumstances, although it's something that lots of employees still deal with, even though there's now legislation that is intended to prevent those things from happening. The legislation is not 100% concrete in certain respects. There's caveats and exceptions here and there, but the general gist of things, of course, is that folks are only supposed to be working when they're getting paid during work time. And again, there shouldn't be, of course, any requirement for you, unless your job is one of the potential exceptions, to respond to these kinds of after hours texts or emails right away. These things can wait almost always to the next day or the next work day in the circumstances. So definitely make sure your employer is aware of this fact, and again, you approach it respectfully and politely. And most employers, when you do so, will be appreciative of that, and they will take the hint in the circumstances and let you go on and be on your way, because that's obviously not appropriate whatsoever. So thank you very much for that question, Melissa. If you're just joining us here, about 22 minutes in now. Again, I am Sephton Leibbrandt, an associate at Samfiru Tumarkin LLP, and we are, of course, the employment lawyers answering all your employment law related questions during our usual 30-minute Q&As, which we regularly have every single week. So thank you for everybody for joining us this afternoon, or perhaps still this morning if you are in Vancouver or BC rather, always in Vancouver, BC or Alberta. Thanks very much. Jumping right ahead now and looking at these further questions here. Looks like Rachel from Facebook has asked, I'm pregnant and my employer said my contract might not be renewed because I'll be on maternity leave soon. Is that considered discrimination? So that sounds certainly quite concerning, Melissa. Obviously, maternity leave is protected ground. Under the legislation, certainly under the Ontario Human Rights Code, and so the suggestion that because you are going on maternity leave, that these folks aren't going to renew your contract, or even the optics of the timing of the two things occurring, in the same space of time does not look good, obviously, from an optical perspective for your employer here. It may well be discrimination, or at least the optics of discrimination, certainly, because obviously the employer cannot make determinations about your employment based on a protected ground under the Human Rights Code, regardless of whether it's maternity, so in this case it would be sex or family status, gender, race, color, ethnicity, citizenship, so on and so forth, many protected grounds. Those factors can never be even a 1% influence in what your employer decides to do with respect to employing you at a company or not. And so any circumstances or fact that suggest that there may be a relationship between a protected ground and the Human Rights Code, and the decisions being made with respect to your employment and the continuance or not continuance of that employment is something that may well be discriminatory and entitling you to human rights damages under the Human Rights Code and the circumstances. It may also be a violation of the Employment Standards Act in Ontario as well if you are on the leave in the circumstances, because of course a maternity leave is a job protected leave in Ontario. One is entitled to that leave and the circumstances, and of course the requirement and obligation of the employer, both under the ESA, the Employment Standards Act, and the Human Rights Code, is if you come back from that and your current job, your previous job that you had with them was not available, to put you into a comparable role at the company in the circumstances. And so the obligation there is entirely on the employer. It sounds like from your question that these folks are not doing that, and because of your leave of absence that they anticipate here, that they're not going to renew your contract, which is resulting at the end of your employment with the company. Again, that sounds to me to be optically looking extraordinarily bad for the employer, and certainly something you want to reach out to us about in the circumstances to have a further assessment there in terms of what your legal entitlements are and the liability of your former employer for potentially human rights damages in these circumstances. So absolutely reach out to us in that regard, and hopefully you'll see a link pop up at oh yes, now it's come up there, employmentlawyer.ca. We have folks standing by all the time to get you set up with somebody so you can get a thorough legal assessment of your circumstances there. But a great question, Rachel. Really appreciate it because again, it's something that I see more often than previous nowadays. It's folks who are something's happening with respect to some kind of protected ground. It can be maternity, family status, so maternity leave, sex, things like that, gender, so on and so forth, and that's potentially influencing the employer's decision with respect to their continued employment with the company. Age is obviously another substantial factor. Folks who potentially may have been terminated because the employer thinks that for whatever reason that they're getting too old, or that because how old they are, they may be owing them more money in a severance package. Again, those protected grounds under the Human Rights Code can never be a factor, even 1% of a factor in the employer's decision to make to terminate your employment, for instance, or to do anything with respect to your employment in the circumstances. Those are protected grounds, and the employer absolutely must abide by them up to a very, very high threshold called undue hardship, which is quite difficult usually to establish. So thank you very much again for that question, Rachel. Moving right along here, it looks like Dwayne from Facebook has asked, if an employer fired you without notice after 14 and a half years for the following allegations, are you still entitled to severance? It's a very complicated situation. Workplace violence, harassment, bullying, policy, code of business conduct, ethics, employment, relatives, intercompany relationships. Okay, lots of things there, Dwayne. So I assume they obviously allege cause here in the circumstances. The question is whether it's, legal cause. Is it actually just cause for termination? And that's a very, very high threshold to reach. I see many folks, I have many clients terminated all the time, for allegations that are allegedly, cause for termination. And it's actually not cause, because again, the threshold to establish cause is very, very high under law. It's not just simply saying, the employee did something bad here or there. Employees can engage in conduct that may be warranting, some kind of discipline, but many times, and almost always, it's not conduct that usually rises to termination for cause. Termination for cause, in my view, is extraordinarily serious misconduct. Theft, for instance, is a very clear example of what justifies termination for cause. Things of that nature. You really have to establish that there's been a irreparable breakdown in the relationship such that there was no reasonable alternative but to terminate the employer for cause. So if you've been there for 14 and a half years, that certainly favors your position, in the sense that obviously you couldn't have been that terrible of an employee, all considered, if they managed to employ you for 14 and a half years in the circumstances. So long and short of it, Dwayne, sounds like it is a complicated situation. So in that case, absolutely reach out to us. As I mentioned, we have folks standing by to get you set up with somebody, and have a look further at your entitlements and so on and so forth there, to determine what your legal entitlements are. Again, you can see employmentlawyer.ca has popped up there. Definitely reach out to us and get a legal assessment of this situation, because again, after 14 and a half years, you may be entitled to a very substantial severance package if they terminate you with nothing, because again, there's very high thresholds the employer has to meet. If you're in Ontario, they've got to demonstrate that what you did was not only just cause, but to give you nothing was something called willful misconduct, which is even a higher threshold than just cause, to deprive you of your minimum entitlements under the Employment Standards Act. Again, very difficult to establish those at law, those allegations, and the employer really needs to have substantial evidence of serious wrongdoing on your part. So definitely reach out to us there and get a further assessment of your matter, because again, in my experience, employers allege cause, willful misconduct all the time, but it's actually not legally viable in the circumstances. It doesn't amount to willful misconduct, doesn't amount to just cause, and they're entitled to a severance package. And after 14 and a half years, again, the severance package would be quite substantial. So certainly reach out to us in that respect. And a great question, we appreciate it. So it looks like we got through the great bulk of the questions there this afternoon. Thanks, folks, everybody who participated. It's great, have more questions. Please, make sure you tune in again. And of course, if you like what we do here, these 30-minute Q&As, absolutely like and subscribe, regardless of the platform you're on, YouTube, Facebook, whatever it is, because that, of course, helps us do what we do here in the circumstances. And we'd like to know that folks are engaged and wanting to participate in these things. And looks like we got a bunch of participation today, which is fantastic. So thanks very much, everybody. Again, I'm Sephton Leibbrandt, and I look forward to seeing you folks again. I think we probably have another of these sessions coming up probably very, very soon. Probably pop up in a second there in the chat below. Oh yes, looks like my colleague Angus out of BC will be doing this on March the 12th at 1 p.m. Pacific time in that respect. So definitely tune back in, and appreciate everybody, and great session once again this afternoon. So thanks very much. Have a good rest of your afternoon.